Ladies and gentlemen, we have breaking news in the Justin Baldoni, Blake Lively case. A judge has issued their response on the battle for the subpoenas. This is going to dictate the direction of this court case. Could it lead to Blake Lively deciding to settle? Or will she find something within the scope of the subpoenas that gives her new ammunition? We are live breaking this on a Friday. Giddy the hell up. Let's get into it. I have not read this. This was sent to me by my good pal Lauren and also Marilyn. Both people sent it to me. I'm getting documents sent left and right. Here it is, folks. Reading it for the first time. It's only 6 pages. Here it is. We have plaintiff Blake Lively versus Wayfarer. Then we have plaintiff Wayfarer against Blake Lively. Now, I asked my new favorite lawyer friends, Ask Two Lawyers, Donaldson, what they think of this court case and why one is plaintiff versus the other. And they said it's basically who fired the first shots, who took this to court first. And we have kind of both sides trying to subpoena each other. Blake Lively's side has asked for subpoenas that Justin Baldoni's side are saying are way too extensive. Then Blake Lively said in one of the footnotes, basically like, well, we're not trying to find out the contents of the subpoena, like whether or not Justin Baldoni has 5 psychiatrists or 5 mistresses, which is just a real cheap shot to plant in the eyes of people. Well, maybe Justin Baldoni's trying to hide text messages he made or this or that, which again, highly doubtful, but also irrelevant to this case, but, a smear nonetheless. So, let's see what the judge has to say. Judge Lehman, United States District Judge. Wayfarer Studios, Justin Baldoni, Jamie Heath, Steve Sarowitz, It Ends With Us movie, Melissa Nathan, The Agency Group, and Jennifer Abel. Collectively, the Wayfarer parties move to quash subpoenas issued to cellular providers AT&T, Verizon, T-Mobile. The subpoenas by Blake Lively, docket numbers 75 and 93. For the reasons that follow, the motion is granted in part and denied in part. Oh boy, everything's motion granted and denied. That's going to be the whole court. You are both guilty and innocent. All right, let's see what's granted and let's see what's denied. This is, by the way, I'm sure this judge would be a great dad. Well, he's like, everything's negotiated. Well, you can go out to the movies, but you got to be back at this hour. I grant you can go out, and I deny that you can stay out too late. Lively served the subpoenas on or around February 12th, 2025. The subpoenas requested all documents concerning ingoing and outgoing calls or text messages related to telephone numbers belonging to certain Wayfarer parties and related individuals within the time period of December 1st, 2022 to the present, including but not limited to call logs, text logs, data logs, and cell site location information. And again, I think the cell site location information, they later said, we don't need that. The telephone numbers of the Wayfarer parties and related individuals are identified in the subpoenas, but the destination telephone numbers are not. On Valentine's Day, the Wayfarer parties moved to quash the subpoenas as overly broad and invasive. The court ordered the parties to meet and confer and to report back to the court whether any dispute remained by February 24th. After the parties met and conferred, Lively agreed to remove the reference to all documents, remove the request for locational data, and clarify that the subpoenas seek only call logs and text logs reflecting non-content, numerical information regarding ingoing and outgoing text messages. Lively has prepared modified subpoenas reflecting these changes. So, again, this is all part of the negotiation. What they're saying is we don't need to see what was said in those text messages. We just need to see if you made those text messages. My guess is they're trying to put together a timeline for when Jed Wallace got involved. He's the crisis PR person. They want to see if they were communicating with him longer than, they've said. However, by letter of February 24th, the Wayfarer parties reiterated their request to quash the subpoenas. The Wayfarer parties object to the fact that even as modified, the subpoenas continue to cover call and text logs revealing the phone numbers for anyone with whom the Wayfarer parties and other individuals communicated, regardless of whether such communication was related to the claims and defenses in the case. The Wayfarer parties therefore seek to have the subpoenas limited to communications between the subpoenaed phone numbers and other specific phone numbers of parties and witnesses that Lively would provide. So my question, and maybe someone legally could answer this, why can't they do a blanket subpoena and then the judge behind closed doors decides which is relevant and which isn't? Can't they do that? I don't know, maybe not. And again, I guess it comes down to Wayfair saying they have the right to privacy with this non-pertinent information. And Blake Lively's side would say, well, we don't even know what's pertinent or not. Maybe there's a phone number we don't know of that's in Texas, and it's the one he's been using. And we need to find out if that communication was happening. Because you know what, whether you believe it or not, I care about the truth. And of course, protecting people's rights to privacy is, I want all that, sure. But I want the truth. And that's not, I want Justin Baldoni to win. I want him to win if he's telling the truth. If Blake Lively comes up with the information that backs all the receipts and there was this coordinated effort for a long time, I don't believe that's the case. I don't understand why Justin Baldoni would want to smear Blake Lively when his whole film and basically the future of his production company rely on the success of the movie. You would think if you're Justin Baldoni, you would put make bygones be bygones. You would put it aside for the sake of the movie, as long as Blake Lively's not publicly smearing you, right? That's what you would think. So could he be a psychopath? Sure. It's Hollywood. I'm not betting on that. The Wayfair parties therefore seek to have the subpoenas limited to communications between the subpoenaed phone numbers and other specific phone numbers of parties and witnesses that Lively would provide. Lively argues that the purpose of the subpoenas is to lead to admissible evidence regarding communications not only among the defendants, but among the larger network of individuals who perpetuated the untraceable campaign against Miss Lively, which justifies their broad scope. Lively argues that the Wayfair parties lack standing to assert the privacy interests of non-parties. I'm not saying I agree with Lively's camp here, but it is an interesting argument, right? The argument of saying, look, we don't even, what if Jed Wallace has a burner phone number? We want to know, are you texting back and forth with somebody coordinating this quote unquote untraceable campaign? Rule 26B1 of the Federal Rules of Civil Procedure provides that parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case, considering whether the burden or expense of the proposed discovery outweighs its likely benefit. When the party moving to quash a subpoena is a non-recipient asserting a privacy interest, the court must weigh the relevance or probative value of the documents being sought against the privacy interest asserted. Then they cite a court case there. The burden of persuasion in a motion to quash a subpoena issued in the court of civil litigation is borne by the movant. Did I pronounce that right? I know people are telling me how to say these things. The subpoenas, should I get a law degree? Should I go back to school? Does DeVry University have the subpoenas of the Wayfair party's phone records, even as modified after the meet and confer, are overly intrusive and disproportionate to the needs of the case. The subpoenas request call and text logs between certain of the Wayfair parties and any other phone number, in most cases from December 1st, 2022 to present. This request implicates legitimate privacy interests. So at this point, I don't know which way the judge is going. Even though Lively has narrowed her request to exclude the content of calls or messages, the phone records themselves would still contain sensitive information regarding which doctors, psychologists, or even acquaintances the Wayfair party spoke to and when. Looks like the judge is on Baldoni's side. Lively has identified no means to segregate those numbers that may have some relevance to her case from those numbers that would have no relevance and would reveal sensitive personal information. Yes, when you talk about, to use the analogy of a fishing expedition, and again, lawyers out there, please leave a comment if I'm getting this right, but it's like fishing with a spear versus fishing with a net. If you're fishing with a spear, you know exactly what you're going for. You're throwing the spear directly into the marlin. If you're fishing with a net, you might be catching lobsters that, you're all over the place. So they don't even know what they're going for. So how's a judge going to grant them the ability to subpoena things when they're just looking for a little bit of everything? And that's what the fishing expedition is called. That is saying, we're just going to go out there, chum the waters, and see what comes up. So far, I think they're siding more with Baldoni at this point. Lively mainly argues that the subpoenas will help to identify the larger network of individuals who perpetuated a negative media campaign against her. But according to Lively's complaint, this negative campaign did not begin until approximately August of 2024. So let's read the footnote. Lively notes that an individual has no legitimate privacy interest under the Fourth Amendment in numbers dialed on a phone. However, this does not prevent the Wayfair parties from having a privacy interest in their phone records. A privacy interest which is not protected by the Fourth Amendment may nevertheless exist pursuant to a state or federal statute or the common law. distinguishing the Fourth Amendment protections applicable to criminal investigations from the less stringent thresholds. So yeah, if it's a criminal, I think that you have less of a right to privacy than this. So they get into all of that. And again, it looks like it's more siding with Justin Baldoni at this point. Describing actions taken in early August 2024 as the beginning of the plan to destroy Lively's reputation. It is therefore unclear how communications to and from Wayfair parties in 2022 and 2023 would reveal individuals who participated in the campaign. So here's what I'm thinking. I'm thinking the judge is about to narrow the subpoena to, June of 2024, and in that way siding with Baldoni and maybe but still approving to the subpoena. So in some way, saying it's not limited to scope of these specific phone numbers, but subpoena anything starting at that date. That's what I think is about to come. Just giving you my guess. Maybe I'm wrong. More generally, Lively has not provided a basis to believe that the broad discovery she seeks will reveal information regarding unknown participants in the negative media campaigns proportionate to the burden on the Wayfair party's privacy interests. By the way, does anyone know anybody at Celsius? Can I get a sponsorship already? This stuff is good. If I die of a heart attack, blame Celsius, because god damn does this make my heart beat. I haven't felt this alive since my single days. Lively's complaint, I haven't felt this alive since the early 2000s. Lively's complaint already identified many individuals who allegedly participated in a negative media campaign. Lively may make discovery requests tailored to those individuals. She is permitted to use the tools of discovery to identify the contact information or telephone numbers for those individuals. Even assuming additional individuals participated in the alleged campaign, the hope that discovery will turn up information on such participants does not justify the broad scope of the subpoenas. All right, so what they're saying is you can't just do a blanket subpoena and hope that something will come up. You need to know what you're looking for. The subpoenas must be quashed to the extent they seek the phone records of the Wayfair parties. This ruling is without prejudice to the Lively party's service of modified subpoenas more narrowly tailored to reveal relevant information. However, the Wayfair parties have not demonstrated standing to object to the subpoena request seeking the phone records of non-parties. A party demonstrates standing to challenge a subpoena directed to a non-party by showing that he or she seeks to protect a personal privilege, right, or interest. The footnote. Lively has also suggested that the phone records may speak to when and how the defendants and witnesses learned about Miss Lively's harassment allegations, what type of information Lively seeks to discover in this regard, and how it is relevant to her claims, has not been further explained. The ruling here is without prejudice to Lively's use of subpoenas targeted to reveal the particular information relevant to her claims of harassment and retaliation. So then they cite some case law. The Wayfair parties may assert a privacy interest in their own phone records, but they have not provided any basis for asserting an interest in the communications of non-parties. Therefore, the Wayfair parties' motion is denied. As to the portions of the subpoenas which seek the phone records of non-parties, the motion to quash is granted in part and denied in part, so ordered. So what the hell does this mean? Explain this to me. This is where we let TikTok do their work. I think this is a very, I think both sides may claim victory on this. In the end, I want to see the phone records. That's what I want to do. I'm not on one team. I want to see the phone records. I want to know and by the way, you would think if you're Baldoni, you want to prove that you weren't part of this smear campaign and you were just doing your best self-defense here. So we'll see how it all plays out. Leave a comment. I'll have breaking news updates as I'm sure this will continue to spill out into the streets. Coming up next is our afternoon rush, which we discuss Candace Owens responding to a smear campaign. Oh boy, you want to talk about crisis PR? They're coming after us. Believe it. I got more on that coming next.